ti@mail.house.gov. The chair now recognizes himself for the purposes of an opening statement for 5 minutes. I want to thank our witnesses for being here today to discuss the National Emergencies Act, the NEA, and the presidential powers associated with it. This is the first time this subcommittee has held a hearing to examine the NEA, and I hope it will be useful for members to evaluate potential reforms to the NEA, which might be born out of this hearing on both sides of the aisle. The NEA was enacted by Congress in 1976 to provide a framework for Congress to provide oversight and accountability of presidential emergency powers. The law's intent was to allow Congress the ability to review and terminate the president's use of over 120 emergency powers scattered throughout the United States Code. Unfortunately, the mechanisms put in place by Congress were watered down after the Supreme Court case United States versus Chadha, which resulted in the current requirement that Congress must pass a joint resolution and that it must be signed by the president, the very person Congress wants to hold accountable. In effect, this means any check on the president's use of some of the extraordinary powers needs a supermajority to overcome a veto. The NEA also directs Congress to review declarations every 6 months. However, there are currently 41 ongoing emergency declarations under the NEA that date back to the Carter administration, which Congress has not actively reviewed. I say actively, like I don't think they've reviewed like that. Well, I probably shouldn't have said actively. Anyhow, in fact, the only time Congress has effectively terminated an emergency was earlier this year with the passage of House Joint Resolution 7, which terminated the COVID-19 emergency declaration. And this was only after President Biden agreed to end the declaration, signing the resolution last month. It's absolutely beyond time that we look closer at the presidential powers authorized for such declarations that we have allowed to continue indefinitely. It's also time we get a handle on the funding associated with these declarations and where the statutorily required expenditure reports are going, if they're going anywhere, if they're even being produced. It's not clear whether and to whom the required expenditure reports under the NEA have been sent or produced. There is also no definition for an emergency, and unfortunately in Congress, that's a recipe for chicanery under the NEA. The president can declare an emergency for anything he or she deems to be an emergency. There is so much risk associated with this and virtually no checks or accountability. The NEA can lock over 120 statutory emergency powers, some with which seem mundane, but others range from commandeering the domestic transportation network to taking over communication channels and distribution of goods to waiving restrictions on human testing of biological and chemical weapons. The document here lists, do I have that document? Yes, ma'am, thank you. Document here lists pages and pages of authorities buried throughout the code that the president can trigger by declaring an emergency under the National Emergencies Act. Do we know the implication of all these laws? Not to mention the unaccounted for funding that has little to no congressional oversight. I just say no, probably not even little. There might be some complaints, but other than that, practically we have none. I look forward to hearing from our panel today on their thoughts on the risks associated with the NEA and potential solutions for Congress to pursue to finally check executive powers when it comes to these emergencies. I now recognize the ranking member, Ms. Titus, for 5 minutes for her opening statement.
Thank you very much, Mr. Chairman. I also want to thank our witnesses for being here and you for holding this first hearing on the important topic of the National Emergencies Act. Proper implementation and oversight of the NEA of 1976 are necessary to safeguard our democracy and protect our institutions. Presidents are awarded great power in times of national crises so they can make timely and decisive decisions when federal assistance is needed in a hurry. This power is granted since Congress may not have enough time during a true emergency to enact the authorities necessary to protect the American public. It's not like we can get anything done in a hurry, as we've seen in the last few days. The national emergencies declared throughout our nation's history, however, haven't been terminated properly, as was mentioned by the chairman. In fact, most U.S. citizens have lived their entire lives under some state of emergency, and at least one national emergency has been active since 1979, and there are, I repeat, 41 national emergencies in effect today. The perpetual state of emergency that we live in may tempt the president to use the powers he's granted by the National Emergencies Act to circumvent the will of Congress. In theory, presidents of any party can abuse emergency powers, but I would be remiss if I didn't mention my concern when former President Trump abused the NEA to fund the construction of a wall at the southern border without congressional authorization or appropriations. In fact, the former president's very first veto in office was on the congressional resolution attempting to block this misuse of the NEA. Before I became a member of Congress, I taught American government at the University of Nevada, Las Vegas. So we spent a lot of time talking about separation of powers and how Article 1 of our Constitution recognizes Congress first. It enshrines Congress's power to make laws, control the power of the purse, and check the power of the president. In fact, it's Congress's responsibility to affirm its status as a co-equal branch of government and ensure that the system of checks and balances is functioning as intended. This discussion is a matter of principle over politics, a constitutional issue over things that are more fleeting. I hope that we can set partisan policy disagreements aside and focus on oversight and reforms that could be necessary to safeguard our Constitution and democracy during today's hearings, and we rely on the experts for their suggestions. I hope this will reignite congressional oversight of national emergencies the way it was intended. I thank you all for your time and previous contributions to this important topic, and I look forward to your testimony as it informs us of what we might do to evaluate certain proposed reforms. I thank the chairman. I yield back.
Chair thanks the gentlelady from Nevada. Chair now recognizes the ranking member of the full committee, Mr. Larson, for 5 minutes.
Thank you, Chair Perry and Ranking Member Titus for calling today's hearing. We're here to discuss safeguarding our democracy, to strengthen our democratic institutions, and Congress's responsibility to maintain its Article 1 power as a co-equal branch of government. So regardless of the sitting president's political party, Congress needs to conduct oversight of emergency powers used by the executive branch. Now, we'll say in reviewing the testimony from today's panel, it was eye-opening and jaw-dropping. The breadth of the president's powers and the struggle that Congress has been through since 73, 76 in order to try to define a fence, if you will, around those powers. A core tenet of the Constitution is a system of checks and balances, which ensures that no one branch of government has too much control or power. That includes checking the powers granted to a president during national emergencies. This nation does grant extraordinary powers to the president during national emergencies. Presidents can determine what rises to the level of a national emergency and declare such emergency without the approval of Congress. A national emergency declaration in turn unlocks more than 130 standby authorities for the president, even if they're not relevant to the emergency at hand. Congress conducted extensive oversight regarding the president's authority to declare emergencies in 1973, and a Senate Special Committee was appointed to investigate concerns that national emergencies were active for too long and that no congressional mechanism existed to terminate them. I was surprised they actually set this up to look at national emergency powers that were established under the Korean War, and then discovered there was a lot more out there, which caused a lot of concern for Congress. So these emergencies were active for too long, and no congressional mechanism existed to terminate them. So the committee report resulted in the passage of the National Emergencies Act, which formalized the emergency powers of the president, authorized Congress to biannually review these emergencies, and then vote to terminate presidentially declared emergencies as well, which was the Supreme Court in 1983 removed as an unconstitutional legislative veto. But today we exist in arguably what the National Emergencies Act was designed to avoid, a perpetual state of emergency. Currently 41 separate emergencies are in effect. Presidential national emergencies are in effect. The oldest one pertains to sanctions against Iran, which has been renewed annually since 1979. I'm not disputing that subject matter of any of these national emergencies are not important. I'm only arguing that after reading testimony and thankfully calling this hearing, that we do have an opportunity to examine whether addressing these issues in a manner that gives the president indefinite emergency level powers is appropriate. Look forward to discussing what an appropriate balance is. Congress is a deliberative body. It does take us time to deliberate and get things done. I can understand why a president needs authority to react quickly in a true emergency and protect the public, because Congress is slow to react. But in the long term, emergency powers should not be a convenience that is used to circumvent congressional action. And we'll argue and debate what is appropriate and what is not appropriate. Again, it's really an issue of whether or not, or when a national emergency is declared by the president. What can Congress do to put some bounds around that? So the witnesses are clearly highly qualified, much more than me, to discuss this issue for us. But as I always say, I'm not an expert. I'm a member of Congress, and I rely on the experts to close that gap. So I look forward to today's hearing and hearing from our witnesses. With that, I yield back.
Chair thanks the ranking members. Chair would now like to welcome our witnesses, to thank them for being here today. Briefly, I'd like to take a moment to explain our lighting system to our witnesses. There are 3 lights right in front of you. The green means go. Yellow means you're going to be running out of time shortly, and red means, like, got to end it, all right? We would also just encourage you to pull the mic right in front when you're speaking, because some of us flew a helicopter for 30 years and can't hear real well, so it's important that you're in the mic. I ask unanimous consent that the witnesses' full statements be included in the record without objection so ordered. As your written testimony has been made part of the record, the subcommittee asks that you limit your oral remarks to 5 minutes. With that, Mr. Date, you are recognized for 5 minutes for your testimony.
Thank you, Chairman Perry and Ranking Member Titus, for inviting me to testify on the National Emergencies Act. Emergencies present a critical issue of checks and balances in the constitutional balance of power. Congress makes laws and appropriates funds. The president implements laws and spends money. In emergencies, though, Congress gives the president and the executive branch fairly broad leeway because of the need to act quickly. But that doesn't mean Congress wants to give the president unlimited power. Members of Congress want to say and have an important role in reviewing, supporting, or curtailing the president's execution of delegated powers. Congress found a solution nearly 50 years ago in the National Emergencies Act. The NEA provides a generalized framework for handling emergency powers. Separate from the National Disaster Emergency System, also under this committee's jurisdiction, note that there is a separate public health emergency system that we're not talking about today. When the president declares an emergency, it unlocks other laws that provide powers, laws written by Congress delegating congressional powers that the president can use to address that emergency. The NEA gave the president broad flexibility, but required clear reporting and empowered Congress to call a halt through a legislative veto. Any member of Congress can demand a vote to block the president's action via concurrent resolution. Consideration of these resolutions was protected via special procedures, and the president could not block that termination. But that system broke in 1983. The Supreme Court decision, INS v. Chadha, struck down the legislative veto that Congress had relied on to review emergencies. Without that check, the delegation of emergency powers was transformed into something far broader. A president could continue the emergency unless Congress could muster a veto-proof majority in both chambers. Indeed, since Chadha, there has been virtually no check on the president's national emergency powers. Members of both parties complain about perceived abuses of executive powers by the president of a different party, but there were little tools to take action. In 2019, Congress started to exercise its review power. The NEA requires that Congress shall meet for every 6 months to review emergencies. But it never did until 2019, when President Trump declared a national emergency at the southern border. Congress voted 2 times on a bipartisan, bicameral basis to end the emergency. And in both cases, President Trump vetoed the resolution. Under the original NEA, President Trump would not have had the opportunity to veto. Instead, President Biden ended the emergency in his first day in office. President Trump also declared an emergency and a separate public health emergency over COVID in March 2020. That emergency was unchallenged until March 2022 and terminated earlier this year. Last year, the Senate voted to terminate the COVID emergency in March and then again in November, and this year, the House voted with 219 votes and the Senate with 68 votes to terminate the COVID emergency. And ultimately, under some political pressure, President Biden ultimately agreed to terminate the COVID emergency. Prior to this year, emergencies had only been terminated by presidents acting alone, and only for the second time in history has Congress acted like the National Emergencies Act imagined it might. But that does not mean the system works. It is still much harder for Congress to exert its review powers over emergencies, much harder than was intended in 1976. Chadha flipped the logic of the NEA completely. What started as exceptional uses of powers reviewed by Congress is now a system where the president can and does maximize power up until there's sufficient public outcry to require him to stop. The current structure of that system is broken by Chadha and treats Congress as a bystander. You all are left to cheer or jeer the president, and you're left to cheer or jeer the courts in the inevitable litigation, but that's not what Congress was meant to do. The good news is that there is a solution to restore a proper balance of power over national emergencies. I'm going to let my colleagues on the panel speak about the existing powers and the solutions to fix it. However, the bipartisan votes against emergencies have been matched by a bipartisan desire to fix the system. Frankly, it has been inspiring to see members of Congress work together in a time of high partisan tension to show real agency to restore the power to Congress. My written testimony provides greater details on all of these questions and recent legislative reform efforts. Thank you for your time, and I look forward to questions.
Chair thanks Mr. Dayton. The chair now recognizes Mr. Thalem for 5 minutes for your testimony.
Chairman Perry, Ranking Member Titus, members of the committee, thank you so much for inviting me here. My name is Satya Thalem. I'm currently a policy advisor at the law firm of Arnold & Porter and a senior fellow with the Foundation for American Innovation. I should note that I'm here representing my own views and not those of any employer or client. I'll forego restating much of what is in my written testimony and what has and will be said by my esteemed co-panelists, and just emphasize some remarks on a couple points. First, the National Emergencies Act basically itself is a fairly thoughtful solution contemplated to resolve a problem of Congress's own making. Like many things in both executive and congressional practice, individual, sometimes one-time circumstances prompted one-time responses. But over time, those policy responses build up without any systematic reconsideration of their total effect. Indeed, powers meant to be exercised only in the case of an emergency have been observed since before the country's founding. Indeed, Hamilton in the Federalist Papers speaks of powers needed to address, quote, national exigencies. Of course, the word emergency does not appear in the Constitution, and yet Congress, as the sole lawmaking branch, has deemed it necessary to grant emergency powers across hundreds of duly enacted statutes going back decades. The conceit being that the executive, in execution of the law, in the public interest, will need to respond to uniquely emergency situations, though that delegation should be cabined by congressional say. So I would note, although the NEA is badly in need of an update owing to the unforeseen judicial decision, its kind of basic underlying structure is sound and is appropriate for Congress to re-examine it to better assert its Article I prerogative. Second, a conceptual note, and if you'll bear with me, a kind of extended and tortured metaphor. But think of the National Emergency Act not as the direct grant of the emergency power itself, but as a key which unlocks a vault in which is enclosed the actual instruments of emergency response. That is, Congress, when it authorizes through other statutes emergency powers, adds to the tools in that vault. And by declaring an emergency, the president is then able to access these powers. The problem then is that when there's no timer on this vault, nor a plausible way to take back the key. There's no timer on this vault. There's no plausible way to take back the key. My recommendation for this committee and your colleagues is to consider how to reestablish workable limits on both the duration and scope of declared emergencies. Another central conceit: emergencies are, by definition, unpredictable, but they should also be, by definition, time-limited and fairly self-evident. Therefore, Congress does not need to run down the impossible task of proscribing every possible emergency, but rather ensure it has the means to have its say with respect to emergency declarations and the attendant emergency powers based on those generalized aspects. Finally, although I don't see it as my role here today to endorse or discourage any specific NEA proposal that may be pending, I'll leave you with this. In my time at a Senate committee leading the effort to pass a particular proposal that was on the table at the time, a proposal that passed out of committee nearly unanimously, Democrats and Republicans on that committee were actually motivated by different emergency powers and their use, and found different emergency uses distasteful, but they came together to support a single bill which addressed them all. That is as it should be, and the sweet spot for any reform is one that is on its face policy neutral and designed to service only the interests of Congress's lawmaking role vis-a-vis the president, rather than any particular political agenda. Thank you for your time, and I look forward to your questions.
Chair thanks the gentleman. Next, Ms. Goitein, you are recognized for 5 minutes for your testimony.
Chairman Perry, Ranking Member Titus, and members of the subcommittee, thank you for this opportunity to testify. Mr. Dayton explained how Congress lost its power under the National Emergencies Act, and Mr. Thalem previewed how Congress might be able to regain that power. I'd like to elaborate on how emergency powers are supposed to work, why the system is not working, and what the stakes are if Congress does not act. Emergencies, by definition, are sudden, unexpected events that require immediate action. Because they are unforeseeable, Congress cannot address them ahead of time through specific legislation tailored to the circumstances, nor can Congress act with the necessary speed and flexibility to address them once they actually occur. Emergency powers thus authorize a limited departure from the legal norm. Their purpose is to give the president a temporary boost in power until the emergency passes or until there's time for Congress to respond through the normal legislative process. For the past century, we've had a system in which the president can declare a national emergency, and that declaration triggers special powers contained in a whole range of statutes, all of which say something like, in a national emergency, the president can do X. For several decades, though, there was no overarching statute governing this system. There was very little transparency about how emergency powers were used, and there was no limit on how long emergency declarations could last. Congress passed the National Emergencies Act in 1976 to rein in presidential power. It attempted to do this in 3 main ways. First, it provided that emergency declarations would end after a year unless the president renewed them. Second, it allowed Congress to terminate emergency declarations using a legislative veto, a law that can pass without the president's signature. And third, it required Congress every 6 months while an emergency was in effect to meet and consider a vote on termination. As Mr. Thalem and Mr. Dayton made very clear, the NEA is not working as Congress intended. Expiration of emergency declarations after a year, which was supposed to be the norm, is the rare exception. There are 41 emergency declarations in effect today, most of which have been in place for over a decade. In 1983, the Supreme Court held that legislative vetoes are unconstitutional, so now Congress usually needs to have a supermajority in order to terminate an emergency declaration. And for more than 40 years, Congress literally ignored the requirement to periodically review existing emergencies. This state of affairs is dangerous. In 2018, the Brennan Center cataloged 123 statutory powers that become available to a president who declares a national emergency. Today, that number has risen to 135. Some of these powers carry enormous potential for abuse. To give you just one example, there's a law that allows the president to take over or shut down wire or communications facilities. This provision was last invoked during World War II when wire communications meant telephone calls and telegrams, and most American households didn't even have a telephone. Today, it could arguably be used to assert control over US-based internet traffic. It's not hard to see how laws like that could be abused to consolidate power or undermine democracy. But there's a softer form of abuse, and that's the use of emergency powers to get around Congress when Congress doesn't support the president's policy goals. In recent years, we've seen that type of misuse by presidents of both parties. While that may not sound as alarming as shutting down communications facilities, it undermines the constitutional separation of powers. And in the long run, the separation of powers is perhaps the most critical protection for democracy that we have. Fortunately, there is a legislative solution that has broad support on both sides of the aisle. The central aspect, the central piece of this solution is a requirement that presidential emergency declarations would terminate after 30 days, unless approved by Congress using expedited procedures that would allow any member to force a vote and would prohibit filibustering in the Senate. If approved, a declaration could last up to a year, but if the president wanted to renew it, he would again have to get congressional approval. This common sense solution gives the president flexibility when it's most needed in the immediate aftermath of a crisis, but allows Congress to step in and act as a backstop against abuse or overreach. Thank you very much, and I look forward to your questions.
I thank you. The chair thanks you all for your testimony. Now be turning to questions. The chair recognizes himself for 5 minutes for questions. Before we get into the specifics of potential reforms to the NEA, I just want to make sure we all understand the magnitude of what we are talking about today. The president has, what did you say, Ms. Goitein,
135.
35 emergency powers scattered throughout the code. We'll start with you, Mr. Dayton. Can each of you just tell the subcommittee, in your opinion, what are the top 2 or 3 emergency authorities granted to the president that might concern you?
Well, I think the ones you mentioned initially, the involuntary testing of chemical and biological weapons on American people, and I would say in today's environment, the internet issue that Ms. Goitein mentioned, just given that the internet is central to everything we do and everything in our homes and things like that.
Yeah, I think, I'm sorry.
Go ahead.
Yeah, I think you can't answer this question without referencing the same one, the communications, the ability to shut down. I think also there's language kind of scattered throughout that allows the president to reappropriate funds from a congressionally appropriated account into another through declaration of emergency. So that's not a specific one, but it's kind of a general one that I'd be concerned about.
I would add to that list the International Emergency Economic Powers Act, which allows the president to essentially freeze Americans' assets without judicial process. I do think that particular law requires its own solution, a separate solution from some of the other powers, and we can maybe talk about that later. But I would then add again to the list the power that's given to the director of the Transportation Security Administration to control domestic transportation.
Right.
And then I'm just going to throw in one more, which is the president's ability to detail members of the U.S. Armed Forces to any nation of his choosing.
Yeah, I noticed that. I noticed the nexus and all these powers between the military and the emergency itself. And many emergencies, I'd argue most, don't have anything to do with the military at all. And that one in particular, I read that in detail to other countries. We might have. Does any? I'm kind of going off my own script here, but that's okay. Does every single emergency invoke all of the powers across the spectrum for the duration of the emergency? So as long as one emergency exists, the president has the 135 now powers, even though there might be unrelated to the emergency at hand. Is that correct?
That's true for most of them. The National Emergencies Act itself does not include any requirement that the powers invoked relate to the nature of the emergency. Some of the emergency powers, the individual powers, have additional requirements in them, circumstances that have to be met. Most of them do not. So dozens of emergency powers are available to the president regardless of whether they relate to the nature of the emergency.
So comforting. Ms. Goitin, as long as I'm with you, understand from your testimony that of the 76 national emergencies that have been declared, 41 are still active, yet accordingly, the required expenditure reports have not been submitted for more than 20 years. Is there any way of knowing whether they've even been completed? And where are they supposed to be going? Who's supposed to get them?
Let me give you a little more detail on that. The emergency declarations that rely solely on IEPA, the International Emergency Economic Powers Act, reports for those declarations have been submitted. For the other non-IEPA emergency declarations, we have been unable to find reports for almost any of those other emergencies. There was a report filed for the Katrina emergency, but we've been unable to find other ones. And when the IEPA reports are filed, there is a notation in the congressional record, so you can see it's been filed. You can't find that notation for other emergencies. With respect to the 9/11 emergency in particular, we've done some digging, speaking to staffers, committees, where they really should be getting these reports, and they appear to be not getting them. There was also a reporter who filed a FOIA request, we filed one as well, several years ago for the reports for the 9/11 emergency declaration going all the way back to 2001. And the Department of Defense, which has been delegated the authority to submit those reports for the 9/11 emergency declaration, basically told the reporter that the reports don't exist.
I'm sorry, say that last part?
Told the reporter that they were unable to find them and that they had performed a search thorough enough that if the reports existed, they would have found them.
Also comforting. All right, my time's expired. The chair now recognizes the gentlelady from Nevada, Ms. Titus.
Thank you. Excuse me. You mentioned a solution is for Congress to exert its authority to end an emergency without it going to the president for needing his buy-off on it or his signature. How does the suggestion you made at the end of your talk, Ms. Goitin, get around the Chadha legislative veto decision?
I'm happy to weigh in, and other witnesses might want to as well.
It doesn't matter who, just you mentioned that solution, that's fine.
Yes, no, I'm happy to explain. The way that it works is that it requires the emergency declaration, or provides that the emergency declaration expires automatically after 30 days. And so if nothing happens, it expires. It doesn't expire because there's been a legislative veto. It expires because Congress said this can last for 30 days. However, Congress can vote to extend it, and of course that is a legitimate act of Congress, one that the president is clearly going to sign because it's the president's emergency declaration, and that then becomes an act of Congress that extends the emergency.
Mr. Dayton, you want to add to that?
Yeah, just to extend slightly, the core concern in Chadha is that you have bicameralism in presentment. And what this does is by having the joint resolution and then the signature, you satisfy the core requirements of Chadha. This is, and it becomes just like any other law. So it's fairly straightforward in that sense. And this has been discussed, as I note in my written testimony, since the 80s, immediately after, within a year, then Senator Biden wrote a piece on this in a law review essay, and there was a fair amount of discussion at the time. I think they hadn't worked out the procedural details, unfortunately, and so there were a series of amendments to a number of statutes, not just the National Emergencies Act, that were impacted by this, that just changed the requirement to a joint resolution without the sunset.
I don't think it's been challenged, but some people would argue that the War Powers Act is unconstitutional based on Chadha. Is that right?
Well, the War Powers Resolution has a couple of additional complications. There are some scholars who've argued that Chadha doesn't apply. I don't think that would probably stand scrutiny. And there's been, when the War Powers Resolution was passed in 1973, President Nixon and every president since then has suggested that their compliance with it does not suggest that they think it's legal. And furthermore, the Senate made changes to the War Powers Resolution, and the House did not. So there have been 2 resolutions this Congress introduced by Mr. Gates from Florida, and I think Chairman Perry and I think Mr. Huffman voted for those resolutions, but those actually don't trigger the same processes in the Senate because the Senate changed the Senate procedures were changed, but not the House one. So it's a complicated mess, and as you move through each set of authorities that use these kinds of procedures, some cases they were changed, some cases they weren't. I go through a couple of those in my written testimony, but it's a complicated mess that it's inviting a solution, and I think this is a great opportunity for Congress to sort of reclaim that broader settlement from the 70s that we saw over a large number of issues, and really use this opportunity for bipartisan consensus to get a real win for Congress.
So would it make sense for us to do a study of all these emergency powers that exist out there and try to bring some standardization to them? You mentioned the 30-day limitation. What about the number of times it can be renewed, for example? Does that then kind of run contrary to the fact that an emergency is something special and unusual and you need to deal with it on a one-off basis as opposed to something standard that goes across all these?
If I may, I mean, I think that's worthy of consideration. And I mean, that's what this body is here for, is to deliberate. I mean, there's no way to create a perfect rubric under which every future emergency will fit. So the tension is to make it broad enough that it's applicable when it needs to be applied, but not so broad that it's just limitless and that Congress is basically kind of surrendered, and saying, well, in an emergency, it's up to the president, and then our hands are washed of the whole thing.
If I could add to that, an emergency is supposed to be a short-term event. If it lasts for longer than a certain amount of time, it's a new normal. And the way to address it is not through a permanent state of emergency, but through new permanent laws if necessary, if it becomes a new normal. The reform that we've been talking about is included in several bills that have been introduced by lawmakers on both sides of the aisle. Some of those bills actually do include a 5-year cap on the total length of time that any emergency declaration can stay in place. I think that's a good provision and one that I think this committee should consider.
Thank you, Mr. Chairman.
Chair thanks the gentlelady. The chair now recognizes the gentleman, Representative Van Orden.
Mr. Chairman, thank you very much, and I want to thank you so much for coming here today. This is an incredibly important subject. It's just phenomenal that you're putting this on. I wrote an op-ed in April 2020. I revisited it in March of 2021. It's May of 2023 now, and I'd just like to share this with you if you don't mind. It was called Freedom Over Fear, 1 year on, this one, because those two things cannot exist in the same universe. You're either free or you live in fear. And again, this is written in March of 2021. Our nation is over a year into the COVID lockdowns. What's becoming more apparent every day is that nearly every draconian measure taken by the predominantly Democrat-controlled states and municipalities have not only become counterproductive, but are actually detrimental. What started as a response to a public emergency morphed into a classic government overreach, then devolved into a series of arbitrary and capricious edicts pronounced by petty tyrants who reveled in their newfound personal political power. 2 weeks to flatten the curve, 6 months, now 3 years, now 3 feet social distancing, then 6. Wear a mask, now 2. Total lockdowns, now open, now lockdowns. You can't dine in a restaurant, but you can eat in an enclosed plastic bubble on a sidewalk in front of the restaurant. You can dine in, but you have to wear a mask at the table. You take it off when you sit down, and then you go to the bathroom because COVID only exists in an aisle. Get vaccinated, but you still can't move about freely or be with your family. You must tell people whether or not you're vaccinated. If you say something on a ubiquitous social media not in line with the state, you're disappeared by neo-fascists pretending to be anti-fascists who zealotly ban books and you. Having the audacity to say that someone's job that is putting food on the table for their family is not essential. By ordering the physical separation of family members, threatening fines and imprisonment for holding church services or other public gatherings, closing schools, and locking our children in their homes, The government has isolated American citizens and removed the most powerful support mechanisms possible: faith, family, and friends. This is by design and is wholly un-American. These measures are clear indications that the COVID pandemic has been weaponized by unscrupulous politicians who have been able to terrify many well-meaning citizens into becoming their enforcers. This is why the nations went off the rails. During the times of crisis, men and women of faith returned to their eternal sacred text to find comfort, guidance, and peace. And in secular life, we should have returned to our foundational documents, the Declaration of Independence, the Constitution, and the Federalist Papers for the very same reasons. This did not happen. We're now seeing, and we have saw, the second and third order effects of this gross omissions, and they're horrible. As I said, I penned an op-ed in 2020 centered on the 7 words from the Declaration of Independence: life, liberty, and the pursuit of happiness. The basic thesis being that yesterday, today, and tomorrow, war, depression, virus or not, the meaning of those words do not change. And I paraphrased Hamilton saying that we must either stand for something or we'll fall for anything. And that's exactly what our nation did. I stand by these statements. The farther we got down the road of creating the dystopian new normal, the more people will come to realize that they did not sell their constitutional freedoms, they willingly gave them away to a series of faceless bureaucrats and politicians who became drunk on power. It's my sincere hope that my fellow Americans wake up and realize that our government cannot remove the rights that were endowed by our Creator and once again start living their lives as free men and women. The time to do so is growing short. History will show that the legislative response to SARS-CoV-19 is a combination of the series of the worst public policy blunders and the largest excuse for political power grab in the history of the world. We must hold our elected officials who champion these policies to account and get them as far away from the place of power and influence as possible. So we either believe that our rights are granted by God and are simply articulated in the Constitution, meaning that they are immutable, or we do not. Because if we believe that we can take a pause on our constitutional rights, they are by definition not immutable, which makes them arbitrary and capricious. Those are not the values that our country was founded on. They are not. I believe that our Constitution must be respected for what it is, and that's the foundational document that this nation, the greatest nation that has ever existed in the history of the world, it must be respected as such. So I want to thank the three of you very much. And Mr. Chairman, I want to thank you for holding this committee meeting. I think it's possibly the most powerful thing we can do as members of Congress. And with that, I yield back.
Chair thanks the gentleman. The chair now recognizes the ranking member of the full committee, Mr. Larson.
Thanks. On December 20th, 2020, I got COVID and was released from isolation 10 days later. Same day, my neighbor got COVID and he was dead 6 days later. COVID is the most random killer that I've lived with in 57 years. And we took actions to prevent those deaths and prevented hundreds of thousands of deaths, and yet many people still died. I think there's a reason for the National Emergencies Act. I think there's reasons why elected officials acted out of good faith, given the knowledge we had and the science we knew at the time, and that science changed as we got to know more about COVID and its variants. I think we just need to look at this practically, and from what I gather, is it Thalem or Talem?
Thalem.
Okay, thanks. You don't have to correct me. No. You mentioned rubrics. Which powers, timelines, a review of length of emergency, congressional actions we can take, and then international powers with the IEPPA versus domestic. Those are kind of 4 categories of things that kind of come to a conclusion on. So maybe there's a start for me. I see nodding heads for the record that at least I've got 4 of some number in the rubric to make some decisions on. But Mr. Dayton, on congressional action, you kind of walked up to the line, and I just want to know, were you arguing we should try to create a constitutionally valid legislative veto?
And I'm sorry, can you say that again?
You seem to walk up to the line on legislative veto. Are you arguing we should try to create a constitutionally valid legislative veto?
I think with a sunset system, you can create something pretty similar. It doesn't, in the bills that Mr. Thalem and Ms. Goitin mentioned, they're typically a 1-year extension, and under the original NEA, it could have been cut off after 6 months. And so there's a design question about how you would do that, and in a certain sense, you could have cut off at any time. So there's still some really challenging issues. One is, and to use the COVID example, in the COVID emergency, the emergency that was declared by President Trump and subsequently renewed by President Biden, the only authority it actually claimed specifically was a waiver of Medicaid eligibility.
Right.
And so I think it would be very helpful to also make more explicit the powers that are to be used. Some of that language is in the original NEA, but it's got some language about subsequent executive orders.
I need to ask another question on that. Does the CRA, Congressional Review Act, is that a reasonable replacement using the CRA, which we've been using, but I just wonder if that's a reasonable replacement.
So the CRA would still has the presidential veto issue, right? And so I think if you were to create something similar to the original desire of the NEA that's compliant with CHATA, you'd need the sunset process and the expiration process, and the CRA doesn't have that.
Just we say that the proposals that have been mentioned by default create a sunset for any declared emergency. So that's in statute. That's in a normally duly presented statute. So what Congress is voting on is only to extend, not to veto. It's sort of vetoed by default after a certain number of days. That's one way of thinking of it.
Yeah.
And I was going to say something similar, which is Congress puts sunsets on presidential authorities all the time. That's not constitutionally questionable. So that's all this is. It's a sunset on the president's authority. And then if Congress wants to extend that authority, it does so through a law that the president signs. So there's no CHATA problem there either. So it's constitutionally quite sound, this mechanism.
Yeah, and the constitutional soundness is important. The founders argued legislative vetoes and made a choice not to include it for whatever reason, and sort of hanging our hat on that and stuck with it, I guess. But which is fine. I think legislative vetoes are unconstitutional, but in my view, on the international versus domestic, and I noted in the Brennan Center for Justice in your document, most of these emergencies are probably foreign policy, international related, as opposed to domestic related. Is that relatively accurate?
I would say it's about half and half.
Is that right?
Actually.
Yeah.
I think so.
And then, so is a review, sorry, I'll just quickly, would review be here, or should that be in Foreign Affairs Committee? Have you thought through the wonderful jurisdictional fights that we'd have to? It's
such a good question. I think the National Emergencies Act, as a statute, spans the jurisdiction of almost every committee. In the House, it has been, the jurisdiction over NEA has been given to the Transportation and Infrastructure Committee. I do think if you bite off a very significant authority that's in another committee's jurisdiction, you start to run into problems, and that's one of the issues with IEPA. It is one of the reasons I feel like IEPA, there are many reasons why I feel like IEPA is its own beast and needs to be dealt with separately.
In conclusion, I think this is one issue that I think if we bid it off, most committees would say, thank God. Right? Most committees would say, thank you for taking this, because no one wants it. All right.
Chair thanks the gentleman. Chair now recognizes Representative Zell.
Thank you, Mr. Chairman. And I want to thank each and every one of you today for being here and sharing this information with us, because I think it's going to be very good for all of us. I spent 42 years in police service as a police chief, a sheriff, and many other leadership roles. And during where I live on the Mississippi Gulf Coast, Hurricane Katrina, I had 4 feet of mud and water in my house, and so did just about the entire town that I live in. And one of the things that, as a sheriff or police chief, is that I was always, we knew these storms were coming, and we had some emergency preparedness, and I was given, as chief or sheriff, I had some authorities kind of along the lines that we're talking about here today. But just as soon as things cleared up, we went back to normal operations. And so I think this is very good. And one of the things that I'd like to say today is that after every major storm or event, as the sheriff or police chief, we had reports that we had to do. They were mandatory to do. And to hear that our government can't even find a report is, I guess I should be shocked, but in the short few months that I've been here, I'm not. You know, I think that's something that should be a mechanism that would be required from any agency head or any department in this government. But if we do a study on this, can we also put a timeline on this study as to how we can better, as Congress, do our job so that we can get some good policy and procedure in place? Are there some areas of disagreement that are out there that we could work on that any of you could discuss today?
I'm tempted to say no, just so we can all be friends and move on. I mean, those I think Congressman Larson was repeating this idea of the kind of buckets of questions we have to address. What is an appropriate time limit?
Yeah.
What is an appropriate scope? There's very reasonable disagreement, within those. Is 30 days too short? Should an emergency be considered, something that lasts for 6 months? I'd like to point out something I included in my written testimony. It's useful to think of Congress's role under a reformed NEA as not just the president pulling this way, Congress pulling this way, and Congress ultimately having its say because Congress is the lawmaking branch. But Congress having its say also provides political legitimacy, right? So if an emergency is in fact self-evident and we're all kind of viewing it and it really is constitutes an emergency, having Congress be able to say yes or no to extend it actually bolsters the case that, yes, this is a thing that needs to be, there is a flood, there is a hurricane, that this is something that needs to be responded to, and maybe after 30 days it hasn't been totally addressed before going back to, as you said, kind of normal operating procedures.
If I could add, I've never worked on an issue that had this much agreement, an agreement on both sides of the aisle. And when the first bill that was introduced that included this 30-day termination reform was the Article 1 Act, and that was a bill offered by Senator Mike Lee with 18 Republican co-sponsors. But every Democrat in the Senate Homeland Security and Government Affairs Committee voted for it. And several Democrats joined a letter to leadership asking for it to come to the floor. And as of last year, I think there were 30 Democrats in the Senate and 20 Republicans who had sponsored or co-sponsored some version of that reform. So there is really widespread agreement. I think the one aspect that was controversial in the original bill was the original bill did cover IEPA, and there was an amendment in the committee to strip it, and that amendment was widely supported. Other than that, I think there's been extremely little substantive disagreement as variations of this bill. This bill was then picked up and put into certain Democratic and bipartisan reform packages, again, with very broad support.
I think this is something we might could get done in a timely manner. So with that, Mr. Chairman, I yield back.
Chair thanks the gentleman. Chair now recognizes the gentlelady, Ms. Holmes Norton.
Thank you, Mr. Chairman. This is an enlightening and sometimes frightening hearing. Ms. Gauthier and Mr. Dayton, the President controls the District of Columbia National Guard, while the governors of the states and territories control their National Guards. Do you think Congress should pass legislation to give the D.C. mayor control of the D.C. National Guard, and if so, why?
I'd be happy to answer that question. The answer is yes. It is not only the states in this country, but also the territories where there is local control over the National Guard, Puerto Rico, Guam, the only exception. is Washington, D.C. What this creates is, first of all, a situation in which where there is an emergency that threatens the residents of D.C., the mayor has to go through a bureaucratic process to get federal approval to deploy troops, and we saw the effect of that on January 6th. But the other problem is that the Department of Justice has adopted a sort of legal fiction in which the DC National Guard can operate in non-federal status, even though at all times it is under the command and control of the president. And for that reason, it is not subject to the Posse Comitatus Act. That means that the president can deploy the DC National Guard to act as a domestic police force pretty much at will. And that's a tremendous problem. That's another problem that could be fixed by having the mayor assume command and control over the DC National Guard.
And I share Ms. Goiteen's concerns. I'd add that the DC National Guard was actually created in 1802 by President Jefferson to provide security for the White House, which is a natural need. We now have the Marine barracks, right? The Marines are all over the White House and provide that function. So at least the original understanding of what the DC Guard was for and why it was a federal, why it reported to a federal entity just doesn't make sense anymore. You know, I mean, you can all go over to 8th and G Southeast and see the Guard barracks. So, you know, it seems like that's a place where you just could clean up and treat DC like other territories and still have the full power of the president to use, you know, to federalize guards from any state to provide core services. So, you know, I don't think you run into problems in that way. And frankly, if you know, there are problems in DC that might need mobilization of resources that I don't see why it should flow through the White House. That doesn't make sense.
And to quickly elaborate on what Mr. Dayton said, the reason why Congress gave command and control to the president was not some considered judgment about who was better suited, the DC mayor or the president. It was that there was no DC mayor. When that assignment occurred, there was no local DC government and no DC mayor. The president was the only game in town. So this is an archaic artifact of history, and it should be updated and changed.
Well, thank you. Ms. Goteen, your testimony highlights a number of really shockingly authoritarian powers enabled by national declarations, assuming control over the U.S.-based internet traffic during wartime, suspending the prohibition on government testing of chemical and biological agents on unwitting human subjects. Most of the reforms we discuss here today are geared toward facilitating or expediting the termination of emergencies. Do you believe there is merit in imposing certain substantive limits on emergency powers in accordance with basic human rights principles?
Absolutely. And I think the reform we've been talking about, the congressional approval requirement, is something that can be done immediately. It gives you the most bang for your buck because it curtails the abuse potential in more than 100 different statutes. But I do believe Congress should also review some of these individual emergency powers that are available under the NEA and in some cases absolutely impose some establish some new parameters that will ensure that these powers are used consistently with principles of democracy and liberty.
Mr. Dayton, the National Emergency Act requires the president to disclose which authorities they intend to use when declaring a national emergency. Mr. Dayton, have presidents complied with this requirement?
Not always, and it's been complicated. To use the COVID emergency as an example, I mentioned earlier that the emergency declaration only mentioned Medicaid waivers. However, the deferment of student loan payments was announced by press release by the Department of Education in late March of 2020, early April. And there was no legal authority provided until January of 2021. you know, was that legal? Facially, it's plausible. It certainly wasn't, there wasn't a political outcry to stop it. In fact, Congress actually included some of those provisions or included similar actions. But I think this is an area where we need a healthier system where the president is being very clear about what authorities they want to use. And if they want to use new authorities, maybe, you know, amend the declaration and get a subsequent, you know, confirmatory action by Congress. But I think you could set up something that increases the accountability and, frankly, as Mr. Tallum said, you know, gives political cover to everyone. I think it would have made, you know, if there'd been more of a political conversation at a higher level earlier, we might have addressed some of the concerns that came up in court at a later date.
Gentlemen, ladies' time has expired. The chair now recognizes Representative Carter.
Thank you, Mr. Chairman. Mr. Thalem, how might the invocation of congressional approval or disapproval on the disaster declaration undermine efforts of state and local government in aiding recovery?
Thank you. I think, well, again, I mean, this is part of the consideration for how do we scope, what's the appropriate scope for this National Emergencies Act potential reform. The idea is that it's policy neutral, and I think the question you're asking goes more to the specific authorities that are unlocked, right? So there's the declaration of an emergency, but those don't actually directly grant any authorities. Other statutes do, where they say, here's how FEMA will respond in a natural disaster emergency or so on. So I think that's where you want to look if you feel that there's a deficiency or there's an opportunity for, I think a word the chairman used was chicanery in another context. If there's a missing piece there, that other statute, I think, is the appropriate place to look.
So you agree we should be careful in watching that because there is room for shenanigans or whatever.
Well, yeah, and I think all three of us.
Obviously, making sure that we don't have the ability to slow or damage the recovery efforts. Obviously, in legislative bodies, we use this term all the time, unintended consequences. And so we should be mindful that in our effort to do something good, we don't end up doing something that could be detrimental.
Yeah,
So,
and
Scott, it
I'm
looks
sorry.
like you have a comment.
I was just going to say, reforming the National Emergencies Act in the way that we've talked about would not have any effect on the Stafford Act, which is the primary source of authority for dealing with these kinds of on-the-ground emergencies, natural disasters, that sort of thing. Nor would it affect the Public Health Service Act, which is the primary source of authority for dealing with pandemics. And most of the authority certainly to deal with COVID, for example, was exercised at the state level through state laws and state constitutional authorities that also would not be affected by NEA reform. So I think, I don't think there's too much of a concern that reforming the National Emergencies Act would tread on either the resources or authorities available to state and local governments in emergencies.
There may not be a more vulnerable stretch of America to natural disasters than the Gulf Coast. In my district and in the surrounding areas of southeast Louisiana, people have been preparing for and rebuilding from storms since long before I've been alive. I was born in the wake of Hurricane Betsy. I've lived through Katrina and served in served my community in our time of need. And I was elected to Congress just in time to help lead the disaster recovery after the devastation of Ida. With our governor and my colleagues in the Louisiana delegation after Hurricane Ida, we all stood together. I know disasters. I've lived with them my entire life. I was born knowing that to always have canned goods, water, extra batteries, and supplies, because this is something that we know comes. We don't know how fast, we don't know how long, but we know they're coming, and we know they tend to come faster and stronger, and we know that they don't discriminate against party, race, color, or socioeconomic backgrounds. So we know the significance of the NEA. If the NEA is amended, do you believe that the Stafford Act should also be considered for amendment?
I do not think that the Stafford Act raises the same concerns or necessarily requires the same approach. And I say that because the Stafford Act is much more limited in its definition of what an emergency or a major disaster is, and it doesn't generally provide a lot of open-ended authorities. Rather, it just frees up resources for state and local government. So I think it just presents a whole different set of considerations, and I would not advocate taking the same approach.
And I'm not suggesting the same approach, but my question is, do you believe that the Stafford Act should be reviewed as well as a document that may have lived out its usefulness and perhaps needs to be reviewed in a 2023 scope?
I'm not sure that I have the necessary expertise to answer that question. The concerns that I have are concerns about separation of powers and civil liberties. I, at this point, have not seen those concerns raised in the Stafford Act context. Whether it contains
That's
the
fair.
right...
I got 5 seconds. Do either of you see a necessity or from your vantage point, I understand that may be above your pay grade or in an area that you're not necessarily zeroed in on, but the Stafford Act, as we look at possibly modifying NEA, do you think we should likewise look at modifications to Stafford, not necessarily in the same frame, but because of the vintage
Not necessarily because of the same frame, in the same frame, but yeah, I think exactly. I worked at the Senate Homeland Security Committee, so I think it's outside the scope of my role here, but there's always room for improvement, and there's always unintended consequences, as you say, in how things sort of develop over time, and they always merit review and additional consideration.
And first,
Very quickly, my time is up, so.
my wife's family is from Baton Rouge, so I understand what you all have to go through in Louisiana. Second, I believe the Stafford Act has been looked at a number of times. It's not like the NEA, which is essentially one and done in '76 and never touched again except to change the word concurrent to joint. I think every couple of years there's been some going back and tweaking the Stafford Act because there's a lot of hurricanes and a lot of tornadoes that people need to respond to, and we learn things. So I think there's probably less of a fundamental problem, and I don't think the need for congressional review in the same way is necessary because it's really about unlocking funds. And as I believe Mr. Ezell said, that there's been a good deal of reporting out of FEMA, unlike in this case.
Gentleman's time has expired. The chair now recognizes Representative Huffman.
Thank you, Mr. Chairman, and I want to thank the witnesses, all of the witnesses. Your testimony has given us a lot of food for thought and has been excellent. Clearly, Congress needs to engage and bring some scrutiny to these open-ended emergency authorities. It is long overdue that we do that. But I think anyone who's following this hearing probably also understands that we're going to be challenged to do that. We just heard a member of this committee suggest that the temporary emergency authorities invoked in response to a global pandemic that killed over 1 million Americans, temporary authorities that have now expired, that was literally the worst abuse of authority in the history of the world. We heard that in this conversation here today. Hitler is rolling in his grave because he's been rendered a footnote in history, eclipsed by the evil Dr. Fauci, who dared to save millions of lives potentially. So we've got a credibility problem as we wade into this difficult issue, and that is going to challenge us. This can be a little bit of a Rorschach test, looking through partisan lenses at which authorities we think are being abused, or maybe which authorities we think should be invoked. So that contributes to our challenge as well. Ms. Goyton, we've heard about the incredible scope of some of these authorities. That should give us all pause. The ability to cut off wire communication, such as cellular, internet capabilities, shut down domestic transportation, deploy troops, even perform biological or chemical testing on humans. So many things about this subject matter should give us all pause. But one thing you pointed out in your testimony, I think is also a bit shocking, that the only limitation on a president to execute many of these powers is precedent and political norms, a sense of decency, if you will. And we saw from the previous administration the limits of relying on that. We saw attacking peaceful protesters at Farragut Square, inciting an insurrection. Now, the chairman may not be troubled by that abuse of authority because he was very much in cahoots with the president and reportedly had to seek a pardon for his role in that illegal scheme to overturn the election. But Ms. Goyden, can you go into a little more detail on the vulnerability we have when we rely on norms and a sense of decency as the backstop to the abuse of authority?
The framers set up the Constitution the way they did with checks and balances precisely because they knew that we could not rely on any president of any party to restrain himself or herself. Probably the framers weren't thinking herself, but you get my point. And checks and balances are not an optional feature of the Constitution that can be toggled on or off depending on who occupies the White House. It is a core protection for our democracy, as I said earlier, and it was because the framers knew that eventually the temptation to abuse power, to consolidate power, to get around Congress, whatever it might be, would be too great. We shouldn't be surprised that we've seen that borne out. That's why checks and balances are there. And in the context of the National Emergencies Act, right now they are not working. And so the idea is to find a way through law, not through norms, not through expectations of self-restraint, to shore them up, to prevent that from happening. And if you wait until a president you don't like is in the White House to try to do that, by definition, it will be too late. The time to do it is now as a systemic protection for our democracy, not as a partisan measure directed against any particular president.
Very well said. And are there some authorities that Congress could use right now without a new act of Congress, some checks that maybe Congress has hesitated to utilize in the past?
Well, I do worry that when President Trump declared a national emergency on the border to secure funding for a border wall, he did break a certain norm of self-restraint in terms of using emergency powers to put in place long-term policy preferences that Congress didn't support. I believe President Biden accepted that invitation when he used emergency powers to forgive student loan debt. So I think we've now broken the seal. We've seen it done by presidents of both parties. I do expect to see that in the future, that softer form of abuse that I was mentioning earlier. And as we have discussed, any of the powers, almost all of the powers that exist for the president to use in a national emergency can be used under any emergency declaration, and we have 41 of them in place. So really, right now, we are highly, highly dependent on norms of self-restraint, and those norms have been badly shaken.
All right, thank you. Yield back.
The gentleman's time has expired. The chair now wishes happy birthday to the gentleman from Tennessee and recognizes Mr. Cohen for 5 minutes of questions.
Thank you for the greetings. Appreciate it. 74 and some more. And thank you for the recognition. I waved onto this committee because I've had this issue as one of mine when I was the chair of the Constitution, Civil Rights, Civil Liberties Subcommittee for the last 3 General Assemblies, I think, or 3 legislative sessions in 2019 and 2022. We had hearings on these issues. And we found out that transportation was the proper committee, which makes no sense whatsoever. Made no sense then, and it makes no sense now. Maybe that's one of the reasons why we haven't gotten anywhere with it. Mr. DeFazio didn't have any interest in pursuing it, but it is in this committee. We had good hearings. Ms. Gautier was a valuable witness on each occasion. Chip Roy and I have worked together on it. Mr. Johnson had some interest in it as well. There was bipartisan interest in doing something with this bill. We just didn't. We were not the committee of jurisdiction. So I would hope that the chair would take this up as an issue that could get passed. Ms. Gautier, is there anything, the bills that have been introduced this year, and I know Chip Roy has one that I've joined with him on, is that the best vehicle that you've seen so far, and are there any changes you would recommend or adjustments to that bill?
There have been so many versions that have come together over the course of the last few years, but I would say that there was a version of the legislation that was the process of a long series of negotiations with all of the relevant stakeholders that became an amendment to the omnibus at the end of last year that basically had been through a negotiation process and had the buy-in of pretty much all of the relevant stakeholders. Right now, that particular language isn't in any bill, but that's largely because the bills that we've been talking about, for the most part, have not yet been reintroduced. Right, so with the Article 1 Act, the Protecting Our Democracy Act, the Congressional Power of the Purse Act, the National Security Accountability and Reforms and Accountability Act, all of these bills had some version of the reform in them, but they have not yet been reintroduced. So unfortunately, I can't point you to an existing bill that has the ideal language, but I expect we'll see one very,
But
very
the
soon.
language that was in the final act last year is something you would support?
I would support all of them. I actually believe that all of them are a substantial improvement over the status quo. But I think it makes sense to go with a bill that has been through a negotiation process and has the buy-in of all the stakeholders.
Thank you. Thank you. We'll look at getting that in legislative form and introducing it. Chip Roy to co-sponsor it, and chairman in particular, be most important. This is an important area, and you're right. It should happen when you've got a president who you like, or some people don't like. We've got to go both ways. But I introduced it when Trump was president, introduced it when Biden was president. And it's the issue. The president could get away with all kind of things that he shouldn't, and the Congress is surrendering his power. And I did the same thing with pardons. I had a bill for the whole time that President Trump was in about pardons. I've re-entered it now. I don't care if it's Hunter Biden or if it's Donald Trump Jr. President shouldn't be pardoning his family members, shouldn't be pardoning campaign people, et cetera, et cetera. It goes for either party. And I'd hope it'd catch traction now and become law, because it's the principle that's important, not the individual, because it lives way after us. No matter how long we live, how many birthdays we have, the law would go on, and that's what we need to be looking at. So, and either of y'all have anything you'd like to add, or a little cleanup, or
The one thing I would say is I've been, as I said in my oral testimony, inspired by how Congress has worked together on this issue. And I haven't seen people fall away when the parties switch. So, I know you had interest in this issue during the Trump administration, and you still have interest in the Biden administration. I know the initial bills that I think we're working off of were introduced during the Trump administration by Mike Lee and Chip Roy, right? People who have unimpeachable conservative credentials, and they've continued to push on those issues. And so I think we've seen a lot of principled action, and I should say Chairman Perry joined Chip Roy's bill last Congress. While this committee has not held hearings, and partially because you did in the last couple of Congresses, I hope we can see through to closing that process relatively quickly.
thank you. Joel McCleary was one of our champions, and he put together a group, Mr. Chair, of about 40 folks one night for a dinner to talk only about emergency powers. He was a man that was involved in the Carter administration, but he's very interested in this issue, and I think he had the former leader from Missouri, Mr. Gephardt, was involved. So there's a groundwork of people out there interested in a bipartisan fashion.
And I just
Chair,
want to
thanks
thank
to
you.
gentlemen. No.
Very, very quickly, I just wanted to thank you for your leadership on this issue and for your bipartisan approach. And there's clearly room there's a lot of agreement in this hearing room on both sides of the aisle. So it's very promising.
Yes, ma'am.
I yield back.
Chair thanks the gentleman. Chair recognizes the gentleman from California, Representative Garamendi.
Mr. Perry, thank you. Thank you for holding the hearing necessary. And we need to continue this. It appears as though when we deal with the national emergencies, we're usually dealing with an issue that is red hot at the time. Student loans, pandemics, whatever. And then we try to address the national emergency law based upon that particular problem, and it becomes politically difficult. So, Mr. Perry, given your tenure as chairman of this subcommittee, if we could spend the next 18 months looking at this issue and coming with a proposal that is not based upon the most recent hot-button emergency, which undoubtedly there will be one. I don't know, forest fires and I don't know, whatever. There'll be some sort of a national emergency. And just divorce ourselves from the current hot-button emergency and come with a specific set of proposals to amend the act itself. And I would like to hear from each of the witnesses what that would be, not associated with today's hot emergency, but beyond. Mr. Dalton, what would you do?
In my testimony, I list 3 components, and there's been a couple more that have been discussed here. One, automatic sunset after 30 days and after a year. That would create the forcing function for Congress to act.
Short version, assume that I know what a sunset is. Keep going.
Oh, so the,
two.
you know, the president would have, when the president declares an emergency, it would only last for, say, 30 days until Congress acts. 2, the expedited procedures to allow quick consideration by Congress, right? These are about congressional rules. 3, clear reporting and factual declarations and justifications. And frankly, I think part of the reason the reporting hasn't happened is that Congress hasn't acted. So why send reports if Congress doesn't care? Is I suspect some of the insight in the administrations going back 20 years. And then 4th, I'd make specific that the powers used in the emergency are, 1, related to the underlying emergency, and if new powers are going to be added, it probably needs to reopen the process. Thank you.
Thank you for the ideas, Mr. Tallahan.
Yeah, I think in our written testimonies, there's the legislation that Congressman Cohen and others have worked on. I would just note that, directly to your point, the original National Emergencies Act is policy neutral. It does not speak to whether certain emergency declarations are good or bad or politically fraught. It is policy neutral. It was just rendered ineffective by a court case that the authors didn't anticipate. So any proposal can keep the basic structure that does not mention public health, does not mention forest fires, does not mention anything. It is about a meta structure for how emergencies are run, kind of like the Administrative Procedure Act.
And your proposal reform is what?
It's along those lines. Set a default sunset of something like 30 to 60
So we would agree
days.
with Mr. Dayton. I'm just hustling along here.
Yeah, I can concur with my colleagues.
Okay, very good.
I also concur. There is legislation that was introduced in the last Congress and the Congress before that really, I think, hits a lot of the important reforms that we were talking about that Mr. Thullum and Mr. Dayton just mentioned. And I think now is actually a very opportune time because the COVID emergency has expired. We are in a situation right now where I think calmer heads
You would
can
agree
prevail.
with the 4 points that Mr. Dayton?
I'm sorry, I didn't hear that.
Do you agree with the 4 points that Mr. Dayton laid out? Or would you add to it?
Yes, I do.
Would you add anything to it?
I can't remember if you mentioned the 5-year total limit. Again, some of the bills that have included this core reform of congressional approval have also included a 5-year total limit on how long any emergency declaration can stay in place. I think that is a good idea.
So an additional sunset. Thank you. Mr. Perry, I'm going to yield back in 8 seconds, but I think we need to work. I know we must work on this.
Without a doubt.
And if we can keep it away from the current issue of the day and look at the underlying law and specific reforms to it, I think there's a need, and I think there's an opportunity. Thank you for the hearing.
Chair thanks the gentleman. We're going to do a second round here, assuming the witnesses are okay with that. I suspected it might be a little shorter than the first round because, as you can see, people have other things to do. Not that interest has dropped off. There's just a lot of competing interest. And so the chair will recognize himself for some questions. I want to get a little more granular. There's been a lot of apt complaining, totally valid, and some collaboration here and discussion. But do you know, is there a definition in the current code of an emergency?
There isn't.
So do you propose, has there been one proposed?
I have proposed one myself. There isn't a definition of national emergency included in the bills that have been offered over the last few years. to
Why do you
reform the National
suppose that is? Is
Emergencies
because
Act.
it's too intractable? That's the point of division between the left and the right?
Honestly, it is very, very hard to get agreement on a definition because it is going to be perceived as either too granular, too micromanaging, or not doing enough. And so, to some degree, I think, and rather than try different versions and have them all sort of stripped out and rejected and create this bad legislative history that suggests that no one wants to define it, I think the consensus has been to move in the direction of having these procedural checks rather than try to get at this elusive definition. Now, as I said, I did propose a definition in the testimony that I gave in 2019 before the House Judiciary Subcommittee. I do think it's definable, but it's very, very hard to get consensus on a
Mr.
definition.
Thallam, it seems like you might have some thoughts.
I just, at least on one aspect of a definition, if you start going down the road of providing categorical definitions, it's an impossible task. I mean, you'd have to anticipate an asteroid strike. You'd have to, so there's the obvious things, the things that have happened in the past, but you have to allow for things that we just haven't conceived of. So I think that's another reason to think of the proper way to address it as, no matter what the emergency is, there's a very clear timeline, it's very time limited, it ends by default unless Congress speaks to it, and the president has to be very explicit about, in that time period, here's the powers that I'm being used. And you can still further reform those other emergency powers, right? Go through those statutes and say, hey, those are not appropriate, or those have been abused, we need to pull those back.
So while I agree with everything you've said, each of you, and I know you're champion there, Mr. Dayton, just to engage in a little bit of a colloquy here with you, it seems to me like this is Congress, right? We work on definitions in the law, and it has to be, there has to be a beginning and an end, or somebody is, look, it's the avarice of mankind, right? That's what we're trying to avoid here and rein in. And so to acknowledge that is, it's to say maybe we don't provide a definition, but maybe because of the issue so stated, the reason so stated, but maybe it should be that if the president's going to declare an emergency, that we require the president to define exactly what the emergency is and why it's an emergency, as opposed to defining it, because I do think that there is an emergency at the border. Now, it's been going on for a long time, which probably wouldn't fit your definition, right? It's an emergency that happens every day that Congress just can't seem to, and we can't all seem to get it together and agree to something. But it doesn't mean it's not an emergency problem that ebbs and flows in the state of the emergency. At the same time, I don't necessarily see student loan debt as an emergency that has some kind of existential threat to our country or the people that have the loan or the people that it get. So I think maybe we're looking at it the wrong way, but I don't think we can just disregard the emergency itself. Before I go to you, Mr. Dayton, because I'm going to run out of time here, because I could spend probably all day here on this, and I imagine you could too. I have a lot of concern and angst about the fact that there is no reporting, there is no accountability, there is no record of the money spent. And that is a phenomenal thing to me. I can't even begin to fathom, and can any of you, has there been any start to an accounting, like just a conglomeration of the total number of dollars that have been spent on the emergencies over time that we know of? Not how they were spent, just like how much money was spent that we don't know where it is. Has there been any attempt at even doing that? And I'll start with Mr. Dayton.
I am not aware of one. I will say on the reporting issue, if the president actually needed your vote to confirm the emergency, I think you might get the reports, right? I mean, I think we've seen in cases where powers have sunset. I know there's a current debate about 702 surveillance authorities that I'm not taking a position one way or the other, but all of a sudden, when Congress is about to vote on reauthorizing these authorities, Congress gets a lot of material from the executive branch. So I think one thing you can do here is by putting yourself in the driver's seat, by putting Congress in the driver's seat, saying, Mr. President or Mrs. President, if you don't send us this stuff, we're not going to approve it. All of a sudden, I think you're going to get more, more compliance from the executive branch. And I think also going back, and this is also partially a response to Mr. Garamendi's point, that if there are going to be different definitions of emergencies. And I think the part of the purpose of this structure is to, one, make this a political question that it properly is, and two, we need to ask what purpose a definition serves. Is it to sort of create a norm for the president? Is it for judicial review? Is it to define, to more clearly define the nature of the debate in Congress?
Yes to all. I think it's yes to all of it, but that might just be me. My time has long since expired. The chair now recognizes the ranking member, Ms. Titus.
Thank you, Mr. Chairman. No, it's a very interesting discussion. I was just looking here about the difference between an emergency and a problem. An emergency occurs when a problem suddenly gets worse, and then it becomes an emergency. The definition of emergency is kind of like obscenity. I can't define it, but I know it when I see it. And that's kind of what we've been using. It's interesting when you talk about the power of Congress versus the president. The Congress was put first in the Constitution. It's Article 1. It's of the people. It's supposed to be more powerful than the president. But then you can argue over time the president's become more powerful than Congress, especially in foreign policy. Now, some of that's systemic. You've developed a bureaucracy. You got more access to information. You're one person. You can act quicker than 435. All of that has occurred over time. But it's also true that Congress has just given away power to the president. Whether it's war powers, as we were talking about, budget and impoundment control, AUMFs in specific cases, just giving it away. Now, you mentioned, Mr. Thelman, that when Congress gets back into the process, it will give credibility or legitimacy to the declaration that the president makes, so they work hand in hand. But I would argue sometimes Congress just gives this power away because they want to get the monkey off their back. We don't want to be the one to declare war for whatever reasons. We don't want to be the one to, have to step in and solve this hurricane. So let's just let somebody else take care of it because of politics. It's very hard to separate those politics from that policy. Just wonder if you would care to comment on that.
It is often, I think, is the line I think you're going down. It is not an accident that a lot of this this practice of Congress has happened. Also, by the way, I used that obscenity definition in my written testimony, so we were thinking along the same lines. But that's why it's so hard. I think that is why creating procedural structures that default to it coming to Congress, right? I think that's a necessary condition. It may not be a sufficient condition for Congress. I think I used the phrase building its policymaking muscle back up, but it's a necessary condition to kind of force Congress to have to address things, not just in emergencies, in lots of areas. And I know there's a lot of legal experts in the room, including yourself. I mean, this is kind of like probably better titled the National Emergencies Procedures Act would be maybe a better way to think of it, because it's the procedure underlying the use of authorities that were granted elsewhere. In the same way, the APA is not the grant of authority for regulatory policymaking, but it is an overarching structure, right? But in this case, Congress takes an active role, and by default, and it forces Congress to have to say yes or no, and not just kind of say, well, someone will deal with it.
Mr. Dayton?
I completely agree. I think there's a couple of ways to think about some of these things. One is in terms of accountability, a word we've used, but also you could imagine it is credit, right? To use the this is an issue that will probably split the dais, but if you were in favor of President Trump's border wall emergency, then you get to vote for it as a member of Congress and show your support, right? If you were in favor of President Biden's student loan program, you would get to vote for it. And people would have concrete actions and sort of shared in the credit and shared in the accountability. And I think that would be very helpful for us as a society to have a situation where Congress shares more in that credit. Because right now, in a situation like where we have now, you're sort of bystanders in some of this process. And that's not healthy for Congress. That's not healthy for our political culture.
On this question of definitions, there is a dictionary definition of an emergency, and that includes the element that the event has to be sudden and unexpected. I would say that that is also core to the purpose of emergency powers in our constitutional system. If a problem, however dire, has been around for years and years and years, Congress has had a chance to legislate on that problem. And if Congress has decided that it's better not to legislate on that problem, then it's not appropriate for the president to sort of take over through emergency powers. A system that allows the president to implement long-term policy through emergency powers not only treads on the prerogative of Congress, it lets Congress off the hook, which is part of, I think, what you were getting at.
Well, thank you. I'll go back.
Chair thanks the gentlelady. The chair now recognizes the gentlelady from Puerto Rico, Ms. Gonzalez-Colon.
Thank you, Mr. Chairman. Happy to be here. I think this is an important discussion, and coming from an island that got a lot of natural disasters, a lot of emergencies, earthquakes, and with the pandemic as well. I mean, it is true that sometimes there is a need to extend the state of emergency due to the scope of the problem. So yes, there should be some flexibility, but if an emergency declaration keeps renewing 40 years, 24 years, is really an emergency, or is just a way to have a continuing policy that for some reason Congress or the president do not want to submit to the legislative process. So one of the issues that we were reviewing here is that there are some emergency declarations that date back to the Carter administration. While some may are still relevant, many are clearly outdated and no longer emergency. One of the questions will be, are there any funds still directed to those outdated emergencies declarations?
So the oldest emergencies are the IEPA emergencies, and one of the things about IEPA is that it largely displaces the cost onto the private sector. So the private sector incurs tremendous costs in complying with IEPA sanctions. And of course, there are economic ramifications in terms of they're not being able to do business in certain ways. The cost to the government is less. Of course, over time, it still builds up, and whatever allocations are made to Treasury, to the Office of Foreign Assets Control, OFAC, then go into sort of oversight of these sanctions regimes. But it's not as if Congress is earmarking funds for particular emergencies or for particular emergency declarations. I think if you were getting the reporting you're supposed to be getting, I mean, you do get it for IEPA declarations, but for other declarations, you would know what the money that you are sending out there for more general purposes is actually being used for.
But actually, we're not receiving the reports. So is there any way to know how much the private sector is paying for those kind of emergency measures at that time?
There is no way to know, and you look at something like the 9/11 emergency, which has now been in place for 22 years, and I would expect that that price tag is staggering, because that declaration is still being relied on for things that frankly have nothing to do with 9/11. So as recently as 2017, President Trump relied on the 9/11 emergency declaration to fill a chronic shortage in Air Force pilots. I would like very much to see how much money has been spent.
And how do we enforce those reports? What should be the mechanism to enforce those reports?
Well, you have the power of the purse. Congress does, generally speaking. You could conduct an oversight hearing, and the question is who you would have in front of you to ask questions of. For the 9/11 emergency declaration, it's the Department of Defense that's supposed to be submitting the report, so it might not be this committee's jurisdiction. Maybe some of my witnesses have ideas.
This is absolutely appropriate for language that should go into appropriations. Like, there should be a condition, I don't want to get the specifics of how that was, but these are absolutely appropriate things that Congress has and should ask for, and using the power of the purse, say, hey, this isn't just a call or an email asking for these. This is Congress saying that this is part of your job, executive branch, and we need this to do our job.
Question, I know that the presidents have used past emergency declarations to proceed with activities that don't really relate to the initial emergency. How often or how common is for presidents to use prior declarations of emergency to actually proceed with their priorities?
I'm sorry, I had trouble hearing that.
Yes, how often or how common is for presidents to use prior declarations of emergency to proceed with their priorities?
Again, it's hard to know without better reporting on how those emergency declarations are being used. But I would say that the best example that I think we have is probably the 9/11 emergency declaration, and that has certainly been used for unrelated purposes. So for example, that declaration was used in 2003 to call up reservists and implement stop loss during the Iraq War, which of course had nothing to do with 9/11. And then it's been used since then to sort of artificially prop up military strength in ways that would otherwise either run up against limits that Congress has put in place or require specific congressional authorization. And the declaration is used to do those things without the necessary authorization.
Thank you. My time expired. I yield back.
Gentlelady's time has expired. The chair now recognizes Representative Van Orden.
Thank you, Mr. Chairman. I want to be very clear that this issue is much more nuanced than it appears to be, and I'd like to give you an example. And I will be bragging on the state of Wisconsin. There's a statute, it's 323.10. It says the governor is capable of declaring a state of emergency, but after 60 days, it will expire automatically unless it is affirmed by a joint resolution, which is awesome. So I think that's the framework we could use. However, in the state of Wisconsin, when the governor declared an emergency for COVID, at the 60-day mark, he tried to kick the can down the road and hand it to a woman named Andrea Palm, who was the health secretary, and tried to extend the ability for him to have our state held in a state of emergency that was declared unconstitutional by the Wisconsin State Supreme Court. And here's where I must strongly and vehemently disagree with my colleagues on the other side of the aisle, saying that we must forget about the issues of the day and focus on the long term. The reason I say this is now Andrea Palm works for the Department of Health and Human Services under the Biden administration. So someone who tried to unconstitutionally continue the state of lockdown in the state of Wisconsin was promoted to the federal government. So in fact, we must hold people accountable directly who are responsible. They took 2 years away from our children. Drug and alcohol addiction has skyrocketed. Spousal abuse, child abuse, skyrocketing. Our kids don't know how to read any longer. They don't know how to socialize because of bureaucrats and politicians got drunk on power and they locked down our country. There are still mobile COVID test sites in Baltimore where you drive up in your car and you wait for someone to approach you to test you for COVID. Why? Because the government instilled fear in people. So we all stopped for 60 days in the state of Wisconsin and said, we are lawful citizens, we're obeying the law. But on 61 days, when the government acted unconstitutionally, we said no. And what people try to say is that you can't do both. Well, the same person that adheres to the law strictly is also the same person that stands up when the people who are governing you are not following the law. And that's the nuanced part of what's taking place here, and it's still taking place. So in fact, I want to hold the people accountable that have been doing this because they must, or it will never change. And again, I want to thank you so much. I can't believe that this hearing is not, I mean, this should be the showcase for Congress. It's unbelievable. So let me just, I want to go through each one of you real quick. Do you guys believe that the same person that adheres to these emergencies should be the same person that when they clearly violate the constitutional authority, that they're the ones that stand up and say no, that those can exist in the same universe? Mr. Dayton?
I'm sorry, I was having a little bit of trouble hearing you. Can you restate?
Okay, I just want to be clear, and I want to ask you, states of emergencies should exist during certain periods of time. So the person that adheres to the law, when it's put down lawfully, can they be the same person that says no once those constitutional authorities have expired?
Oh, I think you can easily imagine a situation where Congress, let's say one of these reforms passed, or like happened in Wisconsin, where the legislature would say that's appropriate now, and then come to a different determination when the facts change, right? I think in many ways we saw that over the COVID national emergency here in Congress, where it went from, in the Senate, from 49 votes last March to 68 votes this March.
Excellent.
It's the exact point that by creating a default, also an emergency declaration gives time for Congress or a legislature to weigh in, where they may not within 24 hours or 48 hours of the onset of an emergency, but now you're creating a window and says, Congress or legislature, you have to make this choice. And if this is going to continue, then you either say yes, or if you think it's not going to, you say no. And in that case, it sounded like it was challenged by the court. A statute could be challenged if a president didn't follow the structure that was laid out.
Ma'am? Mr. Chairman, please indulge me for a second. Ma'am?
Emergency powers deliberately give the president a tremendous amount of discretion, especially when taken together, in ways that Congress cannot predict how the president might choose to use them, and Congress can't predict what the circumstances will be. So I think it makes a good deal of sense to have that period of time to give the president flexibility in the immediate aftermath of the crisis, but to have that time for Congress to see how the emergency powers are being implemented and come to its own judgment about whether, first of all, they're being implemented as Congress maybe intended, but also whether emergency powers are the right way to deal with that particular circumstance. So I think
Thank you, ma'am.
makes good sense.
So I just want to be clear that these types of things have been used for political purposes, and by painting people as extremists, you're actually attempting to remove their constitutional rights. And that's been proven over and over again. So, Mr. Chairman, thank you so much, and thank you for coming here today. I yield back.
Chairman thanks the gentleman. The gentleman yields back. There are no other members of the subcommittee that have not been recognized. So with that, we will conclude the hearing for today. I'd like to thank each of our witnesses for coming here, for your time and your expertise. I do ask for unanimous consent that the record of today's hearing remain open until such time as our witnesses have provided answers to any questions that may be yet submitted to them in writing without objection so ordered. I also ask unanimous consent that the record remain open for 15 days for additional comments and information submitted by members or witnesses to be included in the record of today's hearing. Without objection so ordered, the subcommittee stands adjourned.